Now hearing civil matter 1210326, Liu versus Boston College et al.
Yeah, would you come forward to argue the motion?
Good afternoon, Your Honor. I'm Nicole Laughlin, representing Officer Stephen Horgan and Officer Brendan England.
Thank you. And here's Mr. Frederick Liu, who is representing himself. Now, Mr. Liu, you said you didn't have a statement to make. Let me frame the issue as I understand it. They've raised a variety of issues in their motions to dismiss. Only one issue captures the court's attention, and that is the issue of qualified immunity. Under the law, if the officer's conduct here was, if a reasonable officer situated like these officers were, wouldn't have known that their conduct violated your constitutional rights, then you just don't have a right to pursue this case against those officers. And in their moving papers, they sketch out what they think are the facts, what actually happened here. And I want to ask you about what actually happened, and I'll see if I have a dispute here. So let me start by asking you, Mr. Liu, on the night when there's no doubt these officers stopped you, on that night, did you have, prior to any interaction with the officers, did you have any issue with anyone, any fight with anyone, any altercation with anyone? What were you doing before you came in contact with the officers?
Firstly, it was not a night, according to my complaint, and I wish to pass on the issues of the fact, because right now we are in a motion to dismiss, and so the fact described in my complaint have to be taken as true. And the third is my position is that qualified immunity must fall because they didn't cite any substantive law.
Well, respectfully, I'm entitled to explore the situation. The idea of qualified immunity is that they shouldn't have to bear the burden, time, and expense of defending themselves if a reasonable officer would not have been aware that they did anything that would violate the Constitution. So I think I am within my rights to inquire. I have their version, and I need your version. So you're telling me you're not going to answer my question?
I would really pass on the issues, and because it would be unfair to me without discovery, then we go directly to the Rule 56 motions. And
well, you're right, sir. In effect, I'm giving you notice. I'm converting this to a summary judgment, but I'm not denying you the chance to give me your version. I'm asking for your version. So under the rules, I have the authority to do that, and I'm doing it. So let me sketch out what I think the record shows, and you tell me anything where you think this is wrong. The officers are responding to a complaint. They come across you, and that they think that you fit the description of the person they're looking for. They approach you and say words to the effect of stop or hold it, we're going to talk to you. And you say, am I under arrest? And they say, no. And you say, well, am I free to leave? And they say, no. And then they say, show us what you've got in your hands. And you don't. Then they, in effect, under the Fourth Amendment, they do seize you. They handcuff you. They look at whatever it is you have in your hands. They detain you for approximately 1/2 hour. And after that time, they let you go. I further understand that your complaint centers on the fact of that detention, and you do not contend that they used excessive force or the like. Before I get back to you, let me turn to the officer's representative lawyer. Have I got that? That's your version, right?
Yes, Your Honor.
So for these purposes, you concede all that happens. Handcuffs, 1/2 hour, but nevertheless, you say qualified immunity.
Yes.
Now, is there anything wrong with that version?
I can answer that very easily. It's wrong because my complaint stated that they were not they were not interested in my hands, and it was not my complaint speak for itself, and it's not in my hands. And secondly,
Well, did they do anything else to you?
they did handcuff me according to my complaint.
And she admits that for purposes of this motion. They did handcuff you, yes. So that's established. And they kept you from going about your business for about 1/2 hour. She admits that.
My complaint also said that they searched my pockets and took everything out and dumped my belongings into the garbage and cans. And also, my point,
Yeah.
when I agreed
Let's pause on that because your complaint does say that, and so are you admitting that?
But
No. Are you admitting that?
Admitting that there was a pat-down and that...
Well, I think that's inferred. There was a pat-down. They were frisked. His complaint says they emptied his pockets. Now, this is the first time I'm hearing that whatever he had in there was thrown in the garbage, but put that to one side. They searched his pockets?
Contents were removed from the pockets. It's unclear to me whether the officers removed it or whether Mr. Liu removed it himself.
Why did they search his pockets?
They were in pursuit of him due to the alleged assault and battery that had taken place and had reason to believe that he could be armed and dangerous, and they were permitted to make that assumption under the law.
But after they pat him down, the exterior, there's no suggestion anywhere in this record they find an object such as any sort of weapon. See, that's where you come a cropper here. I'm not troubled by the time of the detention. The question is not whether I'm troubled. As I understand the law, at least on the proffer that you have made, they were in search of an assailant. And they come upon Mr. Liu. They think he fits the description, so they detain him. They frisk him on the outside. They cuff him. Now, from his point of view, all of those things, since he is not the assailant for purposes of this case, infringe his constitutional rights to be completely at liberty. Still, up until the time we get to searching him, I think that you admit there was a search.
I admit that there was a search, yes, Your Honor.
All right. Well, then isn't, since I'm treating this like for summary judgment, I don't see any sort of probable cause for search.
Can I interject?
Well, for the moment you're winning. So let's wait and see how far you go. Do you see?
I understand that for purposes, at this motion to dismiss stage, which is what we're originally here for,
Well, I converted it into summary judgment, and now you're on a slippery slope. So I'm not changing it back again.
Right.
Don't we have an issue as to whether they engaged in a search without probable cause?
I would agree that we do.
All right. Then I must deny the motion for summary judgment. And in the case...
Wish to interject because I don't want to confuse this court. First is I didn't say, and my complaint didn't say they throw the two officers throw my whatever out of my pockets into the trash bins. Something else in my hands into the trash bin. That's what I say in the complaint.
Not what was in your pockets.
What on my pocket was on the ground, and secondly, I want to, because it's very important for me to be honest. They didn't frisk me, and whatever that may affect the court decisions. I just want to say that, and the third is this is actually an interesting case because later I learned not from her whether and the state law or the federal law applies. And thank you. That's all I want to say. Thank you.
Well, let me ask you. Did you they asked you to take what was in your pockets out?
No. Upon this, the first part of the court statement was true. Because I remember what Justice Scalia said, if you are not arrested, you are free to leave. So the colloquy was correct. I asked whether I could leave, and they said I cannot. So immediately they handcuffed me, and then pour everything out of my pockets, and without searching, without frisking, and for half an hour they was looking into the content of the pocket, and I say in the complaint with a stick, picking things, and which
but do you complain about that? The looking at the things that were in your pockets. Do you complain about that?
Is that a question?
Is that part of... I know you wrote it in your complaint, but as a practical matter, do you complain about that?
Yeah, I complain being handcuffed, and I complain search without a warrant.
Well, that's it. The search without a warrant. The search without a warrant, at least.
Under state law.
Well, how about under federal law?
Because that's what I don't know now.
Well, under federal law, it's my duty to allow this to go forward, at least to... I don't really see what damages you have, but that's not for me to decide. Let me ask you, Mr. Liu, you want a jury trial on this? You don't want me to decide it?
Yes, I want a jury trial.
That's fine. All right. Stands for trial. So we're clear and we can narrow it. It's the search without probable cause that goes to trial. For the remainder, I think the officers, I rule the officers have qualified immunity. But it's in line for trial.
Thank you, Your Honor.
All right.
I just wish to submit papers.
Yeah, you may submit the papers, and counsel, you take a look at them here.
The counsel has received as we...
Oh, they have?
1 hour ago.
Thank you.
Thank you, Your Honor.
All right.